for this lesson, you're going to want to have out your Chapter 27, Section 1 notes. You should have taken reading notes on the left-hand side, and you should use the space on the right for your notes on this video. And we will be using the bottom portion again towards the end of the video. I have two images here on the screen to begin with. The one on the top left up here is a picture of the United States Supreme Court in Washington, D.C. And the other image, I just chose one of the states randomly, but this is the State House in South Carolina, so the state legislature in South Carolina. And, you know, both, if you're a citizen of South Carolina, both of these, you know, government entities could have an impact on your life. And what we're going to look at today, we're going to look at civil rights. And the objective that I have for you coming away from this video is I want you to be able to say that I can describe how the legal battle for African American civil rights was a question of central versus state authority. And for our purposes here, this would represent central, this would represent state authority. So how does the seeking of rights by one specific group of people, and when I say rights, I mean things like access to public facilities, the right to vote, you know, the right to something maybe as simple as walking up to a counter and ordering a meal without being harassed or kicked out. And so I just want to take a second and do a little exercise. So what I want you to do is maybe on the back of your note sheet, I want you to take these four terms right here, and I want you to rank them. And the order that I want you to rank them in is first will be the body or the idea of law that would be the lowest priority, and at the bottom what would be the highest priority. So that is which, as you go down your list, the bottom one would outrank all of the others, whereas the top one would be outranked by all of the others. So go ahead, pause the video and take a second and jot down these four things in the order of importance. Right? Hopefully you've paused and now you're coming back, and it's not just a weird transition. But so we have these, you know, we have these four ideas. We have congressional law, so that's a law that's made in the United States Congress. We have a constitutional amendment, we have a state law, and then we have a Supreme Court decision. And you put these in some kind of order. And what I want to do is I want to put them in the appropriate order, okay? Because ultimately this should be, and if you want to take a second and pause this and write this down in the correct order if you don't have it right, this should be the order in which the laws of the land are ranked in hierarchy. So does a state have the right to pass laws? Absolutely they do. However, if the Congress passes a law, that law would trump a state law because it would be a federal law. If we were to omit congressional law, so let's say that there is a state law, but the Congress doesn't have anything, the Congress doesn't pass anything in that same area, if a private citizen wanted to challenge a state law and they made it all the way to the Supreme Court, if the Supreme Court made a decision that said that this law was unconstitutional, the Supreme Court wins, right? The Supreme Court and their decisions will be more important than the state law. However, let's say that everybody disagreed with the Supreme Court decision. Now, I'll use an example. One of the most controversial Supreme Court decisions in American history is Roe v. Wade, which legalized abortion in the United States. The only way that could be reversed would be with a new Supreme Court decision or a constitutional amendment. Because what the Supreme Court is really saying is they're saying that this state law violates the Constitution. That's why it's not a good law. So there's one way to defeat a Supreme Court decision beyond another Supreme Court decision, and that would be you add it to the Constitution, because it can't be unconstitutional if it's part of the Constitution. So this is the order that they would go, right? So the same with the congressional law. The Supreme Court can find it unconstitutional. You can add it to the Constitution. So maybe take a second and you know, summarize that for yourself if you need to in your notes. What I want to look at is something hopefully that you took some notes on the left-hand side here, and that is the legacy of Plessy versus Ferguson, and hopefully you remember in 1896, the case of Plessy versus Ferguson made the practice of separate but equal facilities in the United States legal. And that was a legal process through the process of the court system. And what that did is it made segregation of the races something that was okay and valid based on a legal basis. That is what we call de jure segregation. So segregation on a legal basis, segregation that is based on laws, Supreme Court or state court decisions. And that was a very real factor of American life in the early 20th century into the 1930s, 40s, and 50s. Segregation of law. De facto segregation is a different kind of segregation in that is the segregation of the mind. It's maybe inherent either racism or prejudices that make people of different races stay separate from one another just based on their desire not to be around people of another race. And so the two types of segregation that we have in the United States is we have de jure segregation and we have de facto segregation. It's important that you're able to differentiate between those two. What I would ask you, if we were talking about this in class, and what I would ask you to think about right now is, which of these, if you were a leader of civil rights movement, which of these would you try to target to do away with? Would you try to do away with de jure segregation, or would you try to do away with de facto segregation? What we know is that in the 1940s and 50s, an organization called the NAACP, the National Association for the Advancement of Colored People, decided to take on a strategy which was going to speak directly to this reality. Here's the thing, and I want to explain this as clearly as I can. If you look at segregation in the South during the early part of the 20th century, it was both de jure and de facto. Targeting de facto would be difficult because that's changing the minds and hearts of people, whereas changing de jure segregation is something that you could at least target and have tangible victories. You could change the laws theoretically. The NAACP, under the leadership of a man named Charles Hamilton Houston, who was a lawyer, and he would actually pass away pretty young and not be there for the pivotal moments of the philosophy that he really started. But this man, who's in your textbook, Thurgood Marshall, would pick up where Charles Hamilton Houston left off. And they decided that what they were going to do is they were going to take any cases that they could find of African Americans in the South who were being segregated based on de jure segregation, and they were going to challenge them. They were going to challenge the legal basis of segregation. And the way they were going to challenge is that they were going to bring suit. And they were going to try as many cases as they could until they got some that started to win either at the state or the federal level. Now, what we know were that the southern states were committed to both de jure and de facto segregation. And so what Hamilton Houston and Thurgood Marshall realized was that they were going to need to find a case that would challenge the constitutionality of some aspect of de jure segregation, that even if they were to lose in the state level, all the way up to the state Supreme Court, that they had enough to appeal to the United States Supreme Court. Because if they could, even if they lost, if the state law made de jure segregation, and in this case we wouldn't have to worry about congressional law, but we added in here maybe state court decisions upheld the state law, if they could find their way to the Supreme Court and the Supreme Court disagreed with the state courts, it wouldn't matter what the state said, because that would be the supreme law of the land. And the landmark case that you should know of, that we end up with being a watershed moment in the civil rights era, is the Brown versus the Topeka Board of Education in 1954. You can check me on the date. I think it's May 7th, 1954. The decision is handed down that finally cracked the foundation of de jure segregation. It opened the door, because what Brown versus the Board of Education said was looking at Plessy versus Ferguson. So we didn't have to get all the way to a new or a constitutional amendment, we get a new Supreme Court decision. And what they said was, what the Supreme Court said was that separate is inherently unequal. And it opens the door for further challenges to other aspects of de jure segregation throughout the South, and in the North in some cases too, for there to be legal challenges making de jure segregation something of the past. How you then move on to begin to address and think about de facto segregation, that's another lesson and something that we'll look at later. But what I wanted you to walk away with from this lesson was, whether they were successes or failures, and in the bottom section I want you to summarize this for me. I want you to be able to answer this question. What was the objective of mounting a legal battle as a means of achieving civil rights? So if you think of the first step of civil rights, they don't attack de facto, they attack de jure. And what I want you to summarize in this bottom section is, what was the objective of mounting a legal battle as a means of achieving civil rights?